an answer?
Is that a prelude to this case?
What is that?
Ominous drumbeat.
I have nothing.
I was going to say.
Les, what is that?
That's
We
got-
okay?
That's got to be frightening to a lawyer walking up to that podium. A little bit like
Most physicians
the
don't.
15th song, Fever. A little bit like Fever.
It was supposed to be done.
Given credit for it.
That's right.
Mr. Weiner?
If it please the court, this case involves three charges of violations of the rules of professional conduct against Mr. Siskin. We've spelled out Mr. Siskin's background in detail in our exceptions, and I won't mention them at this moment. Two of the alleged violations relate to Rule 8.4c, where Mr. Siskin is said to have made two false statements knowingly in the course of a two-day deposition that was taken of him in April 2004 in his personal bankruptcy case. The third is an alleged violation of Rule 1.9 when Mr. Siskin sued to collect the unpaid balance on the purchase price from a 2004 sale of the remaining 50% interest in the limited liability company that owned the Jefferson Building in Baltimore. Now, of the two violations of Rule 8.4c, the first is said to have occurred in connection with the following question and answer. And this is on page 14 of the deposition transcript. Have you borrowed any money from him, meaning a Mr. Zakaitis? The answer was, I have not personally borrowed any money from Mr. Zakaitis. Now, Bar Counsel contended, and the trial judge found that Mr. Siskin's answer was false because of a March 2002 loan in the amount of $151,000 that Mr. Zakaitis had made to an entity called Transamerican Commercial Limited. Transamerican Commercial Limited, the record showed without dispute, was formed in 1991, and it is owned by a trust also formed in 1991 for the benefit of Mr. Siskin's family. We've taken exception to the trial judge's finding of misconduct, and we submit that there's no legally sufficient evidence to justify a finding by clear and convincing evidence that the loan in question was a personal loan borrowed by Mr. Siskin. In this case, as the Court's aware, there were no witnesses presented by Bar Counsel. Bar Counsel presented his entire case by putting documents into evidence, some of the documents relating to the transaction, some documents being responses to requests for admission, answers to interrogatories. But none of the people who participated in the transaction were called as witnesses, nor was Mr. Kremen, who was the examiner at the deposition, called to testify. We submit that the finding of misconduct is clearly erroneous because the context of the question and answer was in a personal bankruptcy case. And in that context, the issue was whether Mr. Siskin owed Mr. Zakaitis personally, in which case the obligation would have been an obligation of the bankruptcy estate, or whether the obligor on the loan was a third-party entity, and which would not be a part of the bankruptcy case. So what the inquiry was focused on was who is the obligor. And under the evidence, there is no question that the obligor was the corporate entity. The note, which is Exhibit 2 to the request for admissions, which was put into evidence in this case, is a corporate note. The note specifically states, for value received, Transamerican Commercial Limited, the borrower, promises to pay to the order of Frank Zakaitis, the lender, on the maturity date, and it goes on to say $151,000. On the second page of the note, the borrower is identified, and there's a specific thing that says borrower, Transamerican Commercial Limited. and the note is signed Trans-American Commercial Limited by Mr. Siskin. Mr. Siskin was not obligated on the note. There was no conceivable way that Mr. Zukaitis could have tried to collect the loan personally from Mr. Siskin. What's more, Trans-American gave Mr. Zukaitis a mortgage on the Jefferson building that it owned at that time in downtown Baltimore to secure its obligation, and the mortgage is Exhibit 3 to the petitioner's request for admission. And then when the time came to repay the loan, it is undisputed that the loan was repaid by Trans-American, the corporate entity, because in September 2004, Trans-American sold its remaining interest in the building to Mr. Zukaitis, and the amount of the loan was deducted from the purchase price, so that the loan was clearly repaid by the corporate entity. And that appears in Exhibit 8 to the petitioner's request for admissions. Now, the trial judge decided that this loan must have been a personal loan by relying upon evidence that does not, and as a matter of law, cannot support that conclusion. First, the trial judge relied upon the fact that there had been a prior loan agreement in which there was going to be a loan from Mr. Zukaitis personally to Mr. Siskin. The evidence, the undisputed evidence in the record showed that after that agreement had been signed, Mr. Zukaitis refused to make the personal loan and insisted that he would only make the loan to the corporate entity. And in fact, that was what was done, so that the agreement was superseded.
Now, there's no evidence of any personal guarantees.
No, none at all. Next, the judge was obviously swayed by the fact that Mr. Siskin had benefited from the loan, because the proceeds were used for Mr. Siskin's benefit in connection with a debt owed by some other obligation. But if I borrow money to buy my son a car, and I sign the loan, and my son benefits because he gets the car, he benefited from the loan, but I'm the only obligor. And that's essentially what happened here. Third, there was some letter that Bar Counsel made a lot about, in which there was some reference to whether there was a personal loan that Mr. Siskin had made or not. And that letter turns out not to be part of the judge's findings, and what's worse is that every time Mr. Siskin tried to testify about that letter, on redirect on cross-examination he was cut off when he was interrupted, and then on cross-examination there was an objection to the question for the explanation, and his counsel simply abandoned it after Mr. Siskin had tried twice and couldn't explain it. But the letter itself makes it pretty clear. It's true Mr. Siskin personally had obtained those funds ultimately because he used them for the racetrack, but as he testified in his deposition, he didn't borrow those funds from Zukaitis. He borrowed it from the family corporation. And he testified in his deposition that he had routinely borrowed funds that that corporation would generate for his benefit. It's spelled out in the deposition. Now, the underlying premise of the charge that this was false testimony is that somehow the reason why Mr. Siskin said that he had not personally borrowed the money was to hide this transaction from Mr. Kremen. And it wasn't an unstated premise. In fact, Mr. Hine, in his argument to the trial judge at the end of the hearing, and this is on page 125, specifically argued, and the fact of the matter is that he did testify falsely. It did serve his purpose, apparently at the time of the deposition, not to answer questions regarding his relationship with Frank Zukaitis, because he didn't want to discuss those transactions in which he had been involved with Mr. Zukaitis. Now, as the Court knows, neither Mr. Smith nor I tried this case below. We're the newest entries. We've only been in it for a few weeks. But yesterday afternoon, we were looking at the record to see whether you could really justify the conclusion that Mr. Siskin was trying to hide this transaction from Mr. Kremen. And when we looked at the deposition transcript that was in evidence and looked at it closely, we found two things that we hadn't seen before. The first was that bar counsel had only put into evidence the proceedings for one of the 2 days in which Mr. Siskin had testified. The other was that there were a whole bunch of exhibits that had been marked by Mr. Kremen that were not part of the record of this case. And we did what we thought was our professional responsibility. We got hold of Mr. Kremen and we asked him, please, we've looked in the record, we don't see the complete deposition, and we're trying to find out, did the record justify that Mr. Siskin was trying to hide something? Mr. Kremen sent us his entire file of the deposition. And lo and behold, what we found was that there was an exhibit to that very deposition transcript, Exhibit 29, that Mr. Kremen himself had marked. And what that exhibit was a pleading that had been filed on behalf of Mr. Siskin in the bankruptcy case 6 months before the deposition. And in that pleading, which was a deposition exhibit, Mr. Siskin, through his lawyers, had said, and this is in paragraph 6, in April 2002, in order to avoid an impending sheriff sale, Transamerican Commercial Limited, a corporation wholly owned by Enterprise Trust, borrowed a total of $151,550 from Mr. Zakaitis. The proceeds were placed in trust to ensure the correct application and were used to pay an architect's loan against the racetrack, attorney's fees charged to La Mesa, and the cost of an appraisal for the racetrack. The loan is secured by a lien on the Jefferson Building here in Baltimore, owned by Mr. Zakaitis and the borrower, Transamerican. The debtor did not personally borrow money from Mr. Zakaitis, nor did the debtor pledge his assets to secure repayment of the loan to Transamerican. Now, what did that show? What does that show? Everybody at the deposition knew about this Zakaitis loan to Transamerican. There was no effort on the part of Mr. Siskin to hide that loan. It was an exhibit. It had been in the public pleadings. And clearly, Mr. Kremen was not asking about that loan. He knew all about that loan.
Counsel,
Yes.
what you've just referred to
It's
is
not
not a part of the record in
Correct.
this case.
Correct. And I would ask, that's just getting to exactly where I am here. I would ask that this court allow us to hand the exhibit up to the court and for the court to take judicial notice of this exhibit in order to reach a just result in this case. Or stated otherwise, to prevent an unjust result. And I think it's justified by the discussion by Judge Cathell in DeShiel versus Meeks. I think this is exactly the kind of situation that the DeShiel case contemplated. Because what's inconceivable is here's an entire case that got tried on the theory that this man was trying to hide a loan from the examiner when nobody, and I would take it on my shoulders if we had done it, if we hadn't done our job, but nobody, neither bar counsel nor the lawyer for the respondent, bothered to get the full record of what took place at that deposition. And as a matter of fact, nobody, the bar counsel never, to my knowledge, never ever spoke to Mr. Kremen. So I would ask this court to allow us and for the court to consider it in one of two, either in connection with our initial request, which is that the matter be, that the charge be dismissed, or at the very least that it be accepted in connection with our alternate request for relief, which is the request for remand of the case. Because clearly justice was not served in this case. And I can't believe that any fact finder, had he been aware of this, could possibly have found that Mr. Siskin knowingly made a misstatement. The second alleged false statement relates to Mr. Siskin's testimony about his relationship with Mr. Zakaitis. And here the question and answer appeared at pages 10 and 11 of the transcript. The question was, who is Frank Zakaitis? And Mr. Siskin said, he is a client of mine and my son's, and I have some business with him. And here, too, we've taken an exception from the judge's finding that that statement was false because Mr. Siskin was never Mr. Zakaitis' lawyer, and that Mr. Siskin knew it was false because Mr. Siskin hadn't had any reasonable basis for believing at that time that he may have been his lawyer. The reason why we've taken this exception is that there is no clear, in our view, no clear and convincing evidence sufficient to justify these findings. Now, what is this question here? This case is so different from just about every other 8.4 case I've ever seen. Usually the false statement is an objective fact. A lawyer falsely tells a client, I filed suit, when he didn't file suit. Or in the Goodman case, where Mr. Goodman showed up in court and said he was Mr. Smith. Those are clearly objective facts. What does this case deal with? This answer deals with a conclusion. We said it's a legal conclusion. Maybe it's a conclusion, mixed law and fact. But it's a conclusion about what this court in the Shaw case, Attorney Grievance Commission versus Shaw, called a relationship that is a rather elusive concept. And in this case, there was no dispute about the underlying facts. And the underlying facts in this case did not clearly and convincingly show that there was no reasonable basis for Mr. Siskin to have believed or to have said in 2004 that he was Mr. Zakaitis' lawyer. Now, I'm not saying that a statement that's in the form of a conclusion like this can never be a false statement. Obviously, if I've never met a man and he's never heard of me and I testify that I was his lawyer, well, all the underlying facts point in the opposite direction from the conclusion, and therefore there's clear and convincing evidence that I'm not telling the truth. But in this case, the underlying facts in this case, depending upon any moment that you look at them, will justify either the conclusion that he was his lawyer or that he wasn't. It's like a kaleidoscope. We've looked at it a dozen times, and we keep coming to a different conclusion every time we look at it. The underlying facts showed that there had been a long-standing relationship with Mr. Zakaitis. It was undisputed that Mr. Siskin's son was Mr. Zakaitis' lawyer. It was also undisputed that when Mr. Zakaitis wanted to buy into the Jefferson building, he gave instructions to Mr. Siskin to create a single-purpose entity. And Mr. Siskin followed those instructions and created the entity. He gave Mr. Siskin instructions to deed the property to the single-purpose entity, and Mr. Siskin did that. He gave instructions to Mr. Siskin to prepare documents transferring a 50% interest in that single-purpose entity to him, and Mr. Siskin did that. It's undisputed in this record that Mr. Zakaitis reasonably believed that Mr. Siskin was his lawyer when he created this entity and when he transferred the property. And as the case, many of the cases that we've cited to this court have indicated, the client's belief alone is has been held to be a basis for a court finding that there was an attorney-client relationship.
You said that Mr. Siskin's son undisputably was Zakaitis' lawyer?
Correct.
Does the record indicate what, if any, relationship, other than father and son, in a professional way, that Mr. Siskin had with his son in the practice of law? Was there any evidence?
Oh, no, they weren't in the same. The son is down in Florida.
Okay.
They weren't. They did not practice together, but it's clear they did things together.
So he could not have thought that he was Zakaitis' lawyer because of his son's relationship with Zakaitis.
It was the background to the relationship.
Thank you.
And bar counsel actually placed into evidence in this case, and it's Exhibit 15 to the request for admissions that he placed into evidence, Mr. Zakaitis' complaint dated April 1st, 2005, in which Mr. Zakaitis says, Mr. Siskin is my lawyer. And that's bar counsel's evidence. And then bar counsel also offered into evidence, as Exhibit 17 to the request for admissions that he offered into evidence, a letter that Mr. Zakaitis wrote to bar counsel on August the 1st of 2005, in which he says, Mr. Siskin was my lawyer, and look at his deposition testimony is true. So that's what's in the record by Bar Counsel himself. So what do you have from Bar Counsel's case at the hearing? On the one hand, pointing to Mr. Siskin being his lawyer, you have the Siskin deposition transcript, the Zakaitis complaint, the Zakaitis letter. On the other hand, you had some responses by Mr. Siskin that as of 2006, he was of the conclusion, he had reached the conclusion that he probably wasn't his lawyer, that he probably was the lawyer for the entity. But those conclusions can easily change over a period of time as one looks at these records. In fact, Bar Counsel, within the course of 1 week, changed his conclusion as to what this evidence showed. Bar Counsel had proceeded, the principal thrust of this whole case had been that Mr. Siskin was the lawyer for Mr. Zakaitis and committed some misconduct by, in these transactions, not telling Mr. Zakaitis that he could have another lawyer also look at it. Well, part of the problem that both sides had was that whether Mr. Siskin was or was not his lawyer, there was, in addition to Mr. Siskin, a lawyer in Pennsylvania who was looking at these transactions. The other problem, just before the hearing that Bar Counsel faced, was that Mr. Zakaitis said he didn't want to come to the hearing, and Bar Counsel hadn't taken his deposition. But if Bar Counsel had taken his deposition or Mr. Zakaitis had come to the hearing, clearly he would have said what he had said in the evidence that's been put into the record, which was that he reasonably believed that Mr. Siskin was his lawyer. Which then, so what you end up with is that where you have evidence that's in a state of equipoise, we submit that there's no way to say that based on that underlying evidence that the conclusion that was drawn, whether it was drawn, whenever it was drawn, was, so long as it was drawn in good faith, that the conclusion was clearly and convincingly proven to be false and to be knowingly false. And of course, that brings up the context in which Mr. Siskin made this assertion. What Mr. Siskin did in this deposition was to assert the privilege on behalf of Mr. Zakaitis. Now, any lawyer who is careful, and he had to make a split-second decision at the deposition because he's called to the deposition and he's asked this question about Mr. Zakaitis. And he made that statement and then claimed the privilege on behalf of Mr. Zakaitis. Any lawyer, I would submit, worth his salt would be cautious, and out of caution, if there is a close question as to whether someone is a client, would assert the privilege. Because not to assert the privilege would allow a disclosure to be made that otherwise might have been improper to make. And I'm convinced that had Mr. Siskin not asserted the privilege and spilled out some communications with Mr. Zakaitis, we'd have been here on the charge that he shouldn't have claimed the privilege. Now, what did Bar Counsel argue? Bar Counsel argued, well, the reason why, and this is the same thing I read from page 125, the reason why he claimed that Mr. Zakaitis was his client was that he didn't want to tell about his dealings with Mr. Zakaitis in relation to this building. Well, that's a fine argument, except that it's contradicted, in this case, not by evidence that's outside the record, but it's contradicted by the actual transcript, which is in evidence here. And if you look at the transcript beginning on page 37, and this is the second half of the transcript, there are two halves, and each half begins with the number 1. But the second half of it, beginning on page 37 through 40, I think it's 40, maybe 51, Mr. Siskin testified at length about his dealings with Mr. Zakaitis, about this building, about all of these transactions. So that again, the premise for this alleged false statement simply isn't there. I didn't tender this document that I've asked the court to accept judicial notice of, and I don't know whether it would be appropriate.
Just leave it on the table. We'll get it. Put it up here, put up the end here so that Mr. Cockle can get it.
Which then brings us to the third issue here, and I think part of the problem and part of what happened here was that I think everyone got the burden of proof mixed up. And I think the reason, I respectfully suggest that the trial court, again, and I'm sure it wasn't intentional, but at the urging of bar counsel, failed to appreciate the fact that it was the burden of the petitioner to show not only that it was false, but also that it was knowingly false. But what happened, if you look at page 11 of the court's opinion, you'll see that the court took a part of the sentence from the White case, Attorney Grievance Commission versus White, as support for the statement that the the petitioner need only prove that the respondent had made a false statement because, quote, the giving of false testimony itself constituted misconduct. And then the judge ruled on page 5 of his findings in paragraphs 18 and 19 that the burden then shifted to the respondent to show that the statement was innocently made, and that he had the burden to show that by a preponderance of the evidence, and that if he didn't agree with the respondent, if he didn't believe the respondent, then that was evidence enough to constitute the violation. And I see my time is up.
No, you've got a minute.
And in the brief that bar counsel filed on Friday, bar counsel makes that exact same argument. If you look at page 2, the paragraph that begins 1, 2, 3, 4, 5, 6 lines from the bottom, you'll see that that's exactly the argument that he makes to support what the trial judge did. The problem with it is that what the trial judge did what bar counsel argues flies directly in the face of this court's decision in the Clements case, 319 Maryland 389, where the court said, and I just quote quickly, Judge Nally plainly rejected Clements' testimony that at the time of the assignment he believed that the assignment couldn't create a priority. Thus, we eliminate from our analysis that aspect of Clements' defense. A refusal to believe the evidence of a respondent, however, does not of itself supply affirmative evidence of the dishonesty, fraud, deceit, or misrepresentation charge. And that's exactly, unfortunately, what happened here. So if there weren't a dismissal outright because of the failure to prove these 2 8.4 violations, at the very least, we would suggest that the case would have to be remanded, and we would suggest, because there are already findings made to a different fact finder, to apply a correct burden of proof.
Why a different fact finder?
It's very difficult for somebody who's already said, I believe you're dishonest, now to look at it fresh. I just think it is. And I think it's a favor to the fact finder myself, not to put the fact finder in that position.
Okay, sir. Thank you.
The other points we have are set forth there.
Thank you, sir. Mr. Hine.
May it please the Court. Initially, I don't have any objection to this deposition exhibit that Mr. Wiener tendered coming in before the Court because, quite frankly, it's a self-serving document that the respondent, Mr. Siskin, filed as a response to motion for examination of Frank Zakaitis under Bankruptcy Rule 2004 in the Bankruptcy Court. And the language that Mr. Wiener was quoting is language as to how Mr. Siskin chose to characterize the loan that he received from Mr. Zakaitis. If the Court examines Judge Williams's findings closely at pages 7 and 8 from paragraphs 30 through 38 approximately, it will find that Judge Williams was fully cognizant of the other documents that were introduced in evidence that reflected that Transamerican Commercial Limited was being used to provide a security interest for the loan from Mr. Zakaitis to Mr. Siskin. The reality of the situation, however, was that the operative loan agreement was the collateral agreement dated March 20th, 2002, which is between Frank Zukaitis and William Siskind as an individual, and that's Petitioner's Exhibit 1, Sub-Exhibit 1, which were the documents attached to Petitioner's request for admissions. Judge Williams correctly noted that upon review of the documents submitted in the case, that the respondent uses Siskind and Transamerican Commercial Limited interchangeably in legal and business documents, and further found that Mr. Siskind was not merely mistaken or inattentive when he used the name Siskind as the borrower of the loan in the collateral agreement.
Mr. Hine, in your view, had there been a default on the note, could Zukaitis have gotten a judgment personally against Mr. Siskind?
Arguably, yes, I believe it could, based upon the collateral agreement. But the other important considerations,
Well, could he have gotten a judgment on the note?
Yes, he could have gotten a judgment
On the note?
I'm sorry?
On the note itself?
Yes, he could have.
How?
But against whom are you talking about?
Yeah,
How much Siskind?
Siskind.
Could he have gotten judgment against Siskind?
Siskind individually, personally, on the note.
Well,
The straight debt collection.
that would
default
have
on the note.
required some degree, perhaps, of piercing the corporate veil of Transamerican Commercial Limited, but I believe that that was something that was possible for him to do. I think the more important consideration is where the money went when Zukaitis made the loan, and that was another factor that the judge considered in determining that this was a personal loan, and Mr. Siskind was fully cognizant of that fact. The money that Zukaitis loaned went through this entity, through an account set up by Mr. Siskind, which he described as an attorney's house account for a separate entity, Casino del Caribe, which had an office address at Mr. Siskind's law office, was fully controlled by Mr. Siskind individually, and which had no connection to Transamerican Commercial Limited.
But what, I guess, getting back to it, does it make any difference if a creditor is willing to lend money to an entity, corporate entity, doesn't ask for personal guarantees, and is satisfied with the creditworthiness of the entity? What difference does it make what the entity does with the money? Why does the creditor care?
The entity never received the money. The money never went to Transamerican Commercial Limited.
Never went through there?
It never went to Transamerican. It went to Mr. Siskind's account that he had set up in the name of Casino del Caribe, from which it was then wired out to New Mexico to satisfy the lien against La Mesa Racing LLC, which again is another completely separate entity that Mr. Siskind had an ownership interest in, which had no connection whatsoever to Transamerican.
Is there anything in the record to show any kind of paper trail between the entity and Siskind that would have permitted the money to be paid directly to Siskind?
The evidence of that comes in the form of Mr. Siskind's response to request for admissions, which is part of the record, as well as, I believe, in the answers to interrogatories that were provided, in which the information about how the money went from Mr. Zukaitis to Casino del Caribe and then out to New Mexico to repay the La Mesa judgment lien. That's the evidence of that. And Mr. Siskind, I believe, acknowledged all of that in his testimony as well.
In this paper trail, Transamerica does not appear in any way in the money coming from Mr. Zukaitis and where it ends up.
Correct.
It doesn't go, there's no document signed on behalf of Transamerica agreeing to how this wins its way through ultimately out to
Not in the money trail. The only involvement of Transamerican was for
security
interest provided to Mr. Zukaitis, giving him an interest or possible
Do
interest.
the security documents recite that the security is being given for Zukaitis sending $151,000 to Del Caribe so that they could send it out to pay the debts out at La Mesa?
The security documents do not. I don't believe there's any reference to Casino del Caribe in those documents.
Is it just a recital of consideration in the security documents is for what? $10 in hand received and other considerations, or what?
No, it recites the loan of $151,500.
To Transamerica.
Yes, in that document. But the real facts of the matter were that Transamerica never received those funds. And that document, again, is just a security document securing a personal loan from Zukaitis to Siskind. And that's what Judge Williams found upon review of all of the documents.
Doesn't that simply secure the note?
I'm sorry?
The security instrument would secure the note, would it not?
The promissory note and the mortgage agreement gave Mr. Zukaitis protection in the event of a default on the loan that he would then.
But, I mean, does the mortgage this is a question, does the mortgage recite that that the security is given to secure the note, an identified note? Most mortgages do.
Yes, I believe it does.
And the
If
note,
that's your question.
and the note, the payor on the note was?
On the note was Transamerican. But again, the actual paper trail shows that the money never went to Transamerican.
When did Transamerica come into existence vis-a-vis this antecedent loan agreement between Zukaitis individually and Siskind individually?
Transamerican existed sometime well before the loan was made. I believe it was established in the 1990s, and this loan occurred in 2002, March of 2002. So Transamerican previously existed, and as the court will find upon review of the record, Mr. Siskind was involved in a variety of different business entities. But the fact was, again, that this particular loan that was made from Zukaitis to Siskind was first established by the collateral agreement, which sets forth the terms, and it only later became, or it was necessary to provide a security interest at Zukaitis' request. But I don't really want to get too bogged down on that one particular aspect. Also, there was false testimony provided by Mr. Siskind during the bankruptcy case deposition regarding the attorney-client relationship, and that was not simply an isolated question that was asked by Mr. Kremen during the course of the bankruptcy deposition. That goes on for roughly the better part of 5 pages, beginning at page 10 of Sub-Exhibit 20 to Petitioner's Exhibit 1, which is the first part of the bankruptcy deposition. And concluding at page 15, Mr. Kremen asks the question after Mr. Siskind answers the question, why do we keep talking about Mr. Zukaitis when I am telling you I'm not going to tell you my relationship with him? It is an attorney-client relationship with me. Mr. Kremen asks the question, and that is I want to make sure this is very clear on the record, Mr. Siskind. You are saying to me that the only relationship you have with him is as an attorney-client. Is that your testimony? Answer, yes. What counsel for the respondent has conveniently overlooked in presenting argument here today is that Mr. Siskind consistently denied that he had an attorney-client relationship with Frank Zukaitis during the course of the disciplinary process, the investigative stage, and then later also during in response to discovery, he unequivocally stated that he never represented Frank Zukaitis in any legal matter. It was therefore appropriate for the hearing judge, upon review of the deposition transcript, to make the determination that he had given false testimony at his bankruptcy case deposition on April 5th, 2004. That fact alone is sufficient to support the finding that he knowingly gave false testimony under oath, and supports the conclusion therefrom that he was in violation of Rule 8.4c. We're asking the court to apply the Vanderland analysis to this situation involving dishonest conduct by an attorney, in that there are no compelling extenuating circumstances to justify a sanction less than disbarment in this case. The judge considered Mr. Siskin's explanation that he may have misspoken during the deposition due to advanced age and rejected that. There was no other testimony presented as to any mental or physical incapacity from which Mr. Siskin may have been suffering at the time of his deposition. And in fact, the trial judge made a finding that Mr. Siskin was in full command of his mental faculties. On those findings, with the violation of 8.4c, petitioner recommends disbarment as the appropriate disposition of this case. The other information about the attorney-client relationship that may or may not have existed based upon Mr. Zakaitis' complaint would have required that Mr. Zakaitis testify to that fact, which, because there was no documentary evidence ever provided in the form of a retainer agreement or billing statement to support that Mr. Siskin ever did represent Mr. Zakaitis. Mr. Zakaitis chose not to pursue the complaint, and as a tactical decision, it was decided that it actually gave the case some clarity at that point, because Mr. Siskin had consistently denied that he ever represented Mr. Zakaitis in an attorney-client relationship. For that reason, we pursued the 8.4c charge on the deposition testimony.
I don't recall from the paperwork, but relative to when the commencement of the evidentiary hearing before the hearing judge in this case, how much before that did you discover that Mr. Zakaitis was not going to be cooperative?
I originally received notice that he did not wish to pursue this in a letter dated August 27th, which was received on August 30th. I wrote back to him requesting that he continue to cooperate, and he responded in a letter dated September 6th, which was received September 12th, in which he stated that, please note that due to the passage of so much time, my memory is vague on some of the particulars in this case, and I do not believe I will be helpful. So in that late August, early September time frame.
Did you have any communications with him other than that written correspondence between when he first signaled that don't look to me for any help, in which he recanted his contention that Mr. Siskin had been his attorney?
Not that he recanted his contention. I did have some communication with him in the May to June time frame, wherein he expressed displeasure that Mr. Siskin had communicated with him regarding this complaint and essentially had asked him to withdraw the complaint. At that point, I wrote to Mr. Siskin's attorney, Mr. Snyder, at that time to express Mr. Zakaitis' displeasure with that communication having been made, and Mr. Snyder indicated that there would be no further efforts to communicate. But there was never any recantation of his position that Mr. Siskin was his attorney.
So I guess the best or the worst that could be said is he's now just getting forgetful.
Correct.
Okay.
But our reliance is on Mr. Siskin's own position in this case, which was consistently that he never represented Mr. Zakaitis, and to which he testified inconsistently at the deposition. And for those reasons, we consider this to be a disbarable offense under 8.4c.
Thank you, sir.
Thank
Mr. Weiner.
Mr. Weiner, at the last statement you made was that this court, if it were to remand this case, should direct it that it be held in front of a different judge. If I were to tell you that and you also said that would be doing a favor to that judge. If I were to tell you that I'm aware of a circuit court judge whom had an opinion, a case remanded to his court, with the admonition that not him, but some other judge preside on remand, that particular judge didn't consider it to be a favor and thought it was a statement addressing his integrity, would that surprise you that there could be another feeling that trial court judges might have about such language in remand opinion?
I'm sure.
Take it from me, they generally do not consider it to be a favor.
It does put a terrible burden on someone who has made findings to have to reverse one's findings. I mean, that's a personal.
That happens anytime you have a judge trial and a reversal.
To clarify, if I may, what Judge Harrell had asked, the Bar Council knew by August the 30th of 2006 that Mr. Zakaitis was not going to voluntarily come to Baltimore. And the hearing was on January 23rd of 2007. So there's a period of 4 or 5 months. But what's striking is that irrespective of that, Bar Council offered into evidence, and it came in unimpeached, the statement by Mr. Zakaitis that he's my lawyer, and the statement by Mr. Zakaitis that the deposition testimony was true. I think that this case presents vexing issues because, unfortunately, it was tried without any witnesses. The trial court, and perhaps this court too, has to make assumptions about what Mr. Kremen was asking when he asked about these loans without the benefit of Mr. Kremen's testimony as to what kind of answer he was looking for. Was he looking for what we suggest, which was the identity of the obligor, or what Mr. Hines suggests, which is that he was looking to see who somehow might have benefited from a loan that clearly, on which the note is very clear, the sole obligor is the corporation.
Could that have been relevant in the bankruptcy case? In other words, if it had been disclosed in the bankruptcy case, you say it was disclosed through this exhibit, but could it have had relevance? Who actually got the money from the loan?
If he would have asked him, tell me about this particular loan of which they all knew and which you say is not a personal loan, describe this loan to me, then that would have been an altogether different question. But Mr. Kremen already had in possession and was using it as his exhibit Mr. Siskin's complete description of this loan and his description in which he says this, in my judgment, was not a personal loan.
No, but, I mean, was it clear at the deposition in the bankruptcy case that the money lent by Zakaitis went directly, apparently, to Siskin's account and not through Transamerica?
Oh, sure, it was absolutely clear. Everybody knew it. The other partner in the racetrack venture was a participant in the bankruptcy case, so he knew where the money had come from.
Was Mr. Zakaitis, I mean, I gather the object of the exhibit that you shared with us and Bar Council had no objection to was to oppose a deposition of Mr. Zakaitis in the bankruptcy case.
Correct.
Was there ever a deposition of Mr. Zakaitis in the bankruptcy?
No, it got abandoned. Mr. Zakaitis said he didn't want to come down from Pennsylvania, and the fellow who was going to take the deposition said it wasn't worth his effort to go to Pennsylvania to take it.
While it's entirely speculative, though, what if Mr. Zakaitis had been deposed and said, oh, no, it's a personal loan?
He couldn't.
The rest of this stuff was all just manufactured to conceal that fact.
But he wasn't, and the only testimony that's in this record is the testimony of Mr. Siskin, to which they did not take issue, which is that after that collateral document was prepared, Mr. Zakaitis said he wouldn't go forward unless it was a corporate.
But if the money, the proceeds of the loan, never went through Transamerica, never passed through an account with Transamerica's name on it.
Well, that doesn't mean anything. If you buy a house and there's a prior mortgage, and in the settlement the the loan that, oh, I don't mean you, excuse me, if I buy a house and I take out a mortgage to buy a house, part of the proceeds of that mortgage is going to go to pay off the prior mortgage. I never get it. It never passes through me. It goes to somebody else. That doesn't mean it's not my obligation to pay it on my mortgage, but the route that a particular check takes is absolutely of no relevance in connection with whose obligation it is.
Well, it may be so, maybe not, but particularly when you only get one side or one version of why things happen the way they happen, and you manage to block otherwise checking with somebody else. Did it happen that way? Is this the way it was supposed to be?
Well, you didn't block it at all. Mr.
Well,
Zakaitis was available.
that's not what the exhibit you handed up here suggests.
Oh, no.
I don't want you to take this man's deposition.
Well, Zakaitis also filed, I believe, filed an opposition, because there was a war going on, unfortunately, between this Mr. Vincent and Mr. Zakaitis, and Mr. Siskin was caught in the middle of it.
Thank you.